want to help someone out there to gain more knowledge. If you're a returning subscriber, I appreciate you always. Thank you for always stopping by, tuning in to this channel. And if you're new here, you're asking yourself, where am I? This is Lawyers Infohub. It's a platform where I teach law, I share legal tips, I just share my experiences. I bring people on board to also share their own experiences, all aimed at helping you become a better lawyer in whatever endeavor you find yourself. So today we're looking at corroboration in criminal litigation. You know, corroboration is deep, but let's see how we can, discuss it as simple as it can be, so that you can also even teach someone else by me listening to or watching this video. So generally, you know that there's no particular number of witnesses that is required for someone to even call to discharge the onus of proof on either the prosecution or the plaintiff, either in a civil case. Whether you call 100 witnesses or you call 10 witnesses, it's not about the number. It's about the effectiveness of the testimony. It's about the credibility of the testimony. Now, rather, this general rule that there is no number of witnesses that is required for you to discharge the onus of proof, either on the prosecution or the plaintiff, has some exceptions. So, this exception, this is where corroboration now comes into play as one of the exceptions. Now, let's look at corroborative evidence. Corroborative evidence. So when we talk about corroborative evidence, we're looking at the quantum or the quantum of evidence and witnesses that is required in a proceeding. That means that is the piece of evidence that is given in the proceedings to supplement, to confirm. Corroboration is more like a confirmation. Someone has said this, you're bringing another witness to confirm what that other person has said. So it's more like a confirmation or a supplementary evidence given to help if the evidence is already given, for it to have credibility, for it to be more believed. I'm just talking about explaining it in a more literal way for ease of understanding. So it's a piece of evidence given in the proceedings to confirm, to supplement, yes, another evidence that's already been given in that same proceeding. Now, let's look at the case of Nwambe and the state. Nwambe and the state is a 1995 Supreme Court case, 3 SCNJ 77. It's one of the cases where this issue of corroboration was really elucidated, talked about, used. So if you don't mind, check out this case, Nwambe against the state. It defined corroboration too as a confirmation of a witness evidence, but by an independent testimony. Someone has already given an evidence, another person, an independent person, is coming to give another evidence to corroborate, to supplement, to give more value, more weight, to like make that other evidence more believable. Yeah. So it is a confirmation of a witness testimony evidence by an independent testimony. It just corroborative evidence, it's just that piece of evidence that confirms, that supplements, that reinforces, that supports another piece of evidence of the same facts. Yeah, so we're moving forward. We'll try to explain what corroboration is all about, the corroborative evidence and all of that, what it's all about. And the definition, the understanding of the definition helps you to understand further the other intricacies involved. So what is the nature of a corroborative evidence? The nature. You see that corroborative evidence consists of any independent testimony or evidence that is extraneous to the evidence sought to be corroborated. There's already an evidence. Corroborative evidence now comes to reinforce, to supplement, to add more, let's say, value. Using this word value in a literal sense, like, so I already said this, another evidence is coming to support what other person has said in the same proceeding. So that's the nature of corroborative evidence. It follows from one above. That's a witness cannot just corroborate himself. A witness has testified that another witness will now come to corroborate the evidence of that witness. So a witness cannot corroborate himself. So it takes two or more for that to be a corroboration. Now in a criminal case or in a criminal proceedings, when there's a corroborative evidence, that evidence first has to establish that a crime was committed and that the accused person committed a crime. This is very key. If you're bringing in a witness to corroborate evidence of the other witness, this has to be established that the evidence that the offense was committed, and it was not just committed, it was committed by the accused person. So that is the corroborative evidence of a witness in a criminal proceedings or a criminal trial or proceedings, as it were. So corroborative evidence may be oral, it could be documentary, it could also be real. So either way, the essence is that, is it supporting, is it reinforcing, is it supporting, is it reinforcing, is it helping the other evidence? Yeah. So we'll note that circumstantial evidence, if strong, can provide corroboration. This is key. If a circumstantial evidence is that strong, it can provide a corroboration. Yeah. So circumstantial evidence can, if strong, that's the condition, can provide corroboration. Now, an evidence which requires corroboration cannot corroborate another. If someone has said, I saw when he killed this guy, yeah, and that evidence needs corroboration, that evidence cannot corroborate another evidence. So an evidence that requires corroboration cannot corroborate another, which by itself requires corroboration. For example, the unsworn evidence of a child, it cannot corroborate the unsworn evidence of another child. The unsworn evidence of a child cannot corroborate the unsworn evidence of another child. That is, the evidence which requires corroboration cannot corroborate another, which by itself requires corroboration. Now, we look at need for corroboration. Why do we need corroboration? Why is corroborative evidence important? Now, the seriousness of the offense is key. The seriousness of the offense, the serious nature of the offense, and makes corroboration important. Now, the unreliable evidence or nature of evidence of most children. When there's an unsworn evidence of a child, or most times when children give evidence, there is need for corroboration. I know another need for corroboration is to ensure one worthy witness confirms what another credible witness has said. One worthy witness corroborates what another witness has said. So the essence of corroboration is just to confirm, to reinforce, to support the evidence of another, thereby reducing convictions of most innocent persons. Because if a conviction is solely goes scot-free. It's also important to note that there are cases where corroboration is required as a matter of law. So we're going to list out those cases where corroboration is required as a matter of law. In the offenses of treason and treasonable offense, corroboration is very important. It's required as a matter of law. In offense of charge of perjury, corroboration is required as a matter of law. In offense of exceeding speed limit, corroboration is very, very vital. In offense of sedition and sexual offense, corroboration is key, very, very important, required as a matter of law. In offense of breach of promise of marriage, corroboration is required. In the sworn evidence of a child, corroboration is very, very, very important. We talked about treason and treasonable offenses. We say it's the matter of law, it needs corroboration. We've talked about exceeding speed limits, that it needs corroboration as a matter of law. We've looked at sedition and sexual offense, that is need for corroboration. Under this sedition and sexual offense, we'll look at defilement of girls under 13 years, defilement of girls under 16 and 13, and idiot procreation under section 223 of the criminal code, the procurement of defilement of women under threat of fraud and all of the administered drugs. In such instances, in such offenses, corroboration is required as a matter of law. I've talked about breach of promise of marriage. Corroboration is what required. The sworn evidence of a child. It requires corroboration as a matter of law. It's a very important requirement. That an accused person cannot be convicted based on the uncorroborated evidence of a child without oath. The unsworn evidence of a child, to be used as a basis for conviction must be corroborated by an independent material evidence, implicating the accused person. This is very important, very key under the unsworn evidence of a child. So look at where the corroboration is required as of law. We've looked at what corroboration is all about. We've looked at the need for corroboration. We've defined it in the case of 1B and states that corroboration is more like a confirmation, a piece of evidence that confirms the evidence of another. So friends, I just hope you've learned something from this little lecture of mine. Please, if you've not subscribed to this channel, hit the subscribe button and subscribe. Share this video to your friends. They'll be able to learn what corroboration is all about, the need for corroboration, where corroboration is required as a matter of law. So please do stay safe and do stay well. Check out our channel. Look out for other videos we have done to learn more, to share to your friends, your mentees, share to younger colleagues, because I know there are lots and lots and lots of videos that are on our channel, on this channel, that will help you in your practice, that will help you as a lawyer, that will help you in your advocacy. Thank you, and do stay safe. Don't forget to hit the subscribe button and share this video. Take care.